with the requisite quorum as contemplated under Article 251 and 252 of the Constitution. My lords and my ladies, it is our humble submission that the nomination of the second interested party ran afoul the provisions of Article 88 as read with the 82 of the Constitution. We submit that the principles that the court articulated that the commission must be properly constituted cannot have been discharged in order for the IBC to discharge its mandate has to be held in equal, if not greater, force when it comes to approval of the second highest position in the executive of the Republic of this country. My lords and my ladies, the second issue that I seek to persuade you is whether the nomination of the second interested party, while serving as a cabinet secretary, violated provisions under Article 148 as read together with Article 137 of the Constitution. It is not in doubt that at the time of nomination and even approval of his role as to take over the role of the Deputy President, Honorable Professor Kithure Kindiki was serving the people of the Republic of Kenya as a Cabinet Secretary for Interior. My Lord, by its definition, a state officer under Article 260 of the Constitution includes persons holding the position of Cabinet Secretary. He had neither resigned from this position at the time when Parliament approved his nomination. My Lord, Article 149 of the Constitution cannot be read in isolation. It has to be read together with Article 137 2B and 148 1. And the only exception that the Constitution provides for persons who can be nominated for the presidential position are people who are already serving as a president, a deputy president, or a member of public. None of these positions, the second interested party was not serving any of these positions. And therefore, we humbly submit that a person who already holds a position of cabinet secretary at a time of nomination as a deputy president does not satisfy the constitutional qualification set out in Article 137 2B as applied through 148. And therefore, the nomination of the Honorable Professor Kithure Kindiki runs averse the said provisions. My lords and my ladies, via our petition, that is petition number 565 of 2024, we had sought the following reliefs. The first one is a declaration be and is hereby issued that the rights and fundamental freedoms of the first petitioner, including his rights and freedoms under Article 25C, 50, 27, 47 and 145 were grossly violated by the third respondent on the 17th day of October by declining to allow him an opportunity to adjourn and be heard during his replacement of the first petitioner to the office of the Deputy President was also unconstitutional. We've also sought a judicial review of order of certiorari to bring to this court for purposes of quashing the Gazette notice by the third respondent dated the 17th of October, communicating the removal from office of the Deputy President of the Deputy President by way of impeachment. A judicial review of certiorari does hereby issue to bring to this court for purpose of quashing the decision of nominating Professor Kithure Kindiki as the Deputy President of the Republic of Kenya for failing to meet the qualification under Article 137 2B and 3 of the Constitution. In the alternative to that fifth prayer, we have sought that the Honorable Court does make a declaration that the appointment of the Deputy President to fill vacancy arising from the removal of the first petitioner from office pursuant to Article 149 of the Constitution must be read together with Articles 82 and 88 of the cost of this petition. My lords and my ladies, I have refrained from regurgitating what fellow counsels for the petitioners highlighted in respect to the impeachment processes and the violations that we witnessed therein, including public participation and the violation of the right to be heard by the first petitioner. All those are contained in our submissions. That is all, my lords and my ladies.
Thank you.
If it may please you, Your Lordships.
It's me, I don't know.
You know, I remember Mr. Kibe had said that for us who had booked 10, 20 minutes, we can go ahead because he has a long time. I believe that is what he, when we spoke.
We are following the order, and I'm next. You are 58.
It's okay. You can take the floor.
If it may please, my lords and my lady, the appearances for the 10th to 41st petitioners are as previously indicated. For purposes of the order of submissions, my lord, I'll take about 1 hour, 15 minutes. My learned colleagues, Mr. Martin Kamwaro, he has indicated he needs about 25, 30 minutes. And then Mr. Peter Koira, he will take about 10 minutes. So if we could start right away, I think the first thing is our submissions have been furnished to the court alongside a book that we thought it is easier to give the book because, by law monthly, because of what it covers. We thought it is easier to give it as a book. I've given Professor Muigai and Senior Counsel Paul Muite. So, be that as it may, we shall be referring to those submissions. The rest of the advocates we are annexing in our submissions. Just relax. The relevant passages of the book are in the submissions. Now, my lords, for purposes of taking the process forward, I think the first thing we want...
These documents, these books, yes. Are they given as part of the court record or given to us as individuals?
Part of the record. We have referred to those books.
Part of the court record?
Part of the court records, yes.
And then after that?
You can keep or donate.
Okay.
It's part of the record.
We'll be taking the stage. We've not seen this book. I think we'll be taking the stage. We've not seen this book. I think just one copy has been given to Professor Giddle. It would only be fair that we have access to all these documents so that when it's done, at least we'll have had an opportunity to look at what he'll be making his submissions on.
We have referred the 3 passages from the book I can direct him to the paragraphs where the book is referred to.
I think it's only fair that we get copies, so that then we don't get into a
I
situation
can't
where...
afford to give everybody
But
a
really,
copy.
you can't then choose to come to court and say, I'll give this book to certain people, certain parties, and not others. That cannot honestly be.
I think to save time, Ms. Mugai, you can just detail somebody to get copies. Copies
Yes,
yes, so that we can
Thank
proceed.
you, my lord. We shall get them.
Of the relevant pages.
Yes.
Of the relevant pages.
Actually, they are cited.
Yes.
There are just 3 passages that are cited. The rest is for somebody who wants to read the broader picture. Just like Hamilton's Federalist number 65 has been quoted a single passage, but anybody can read the entire Federalist 65. So it's a simple issue, really. I hope this cannot distract me, so I can proceed. And just for the record, I had spoken to my learned colleague, Mr. Professor Ojienda, Senior Counsel, and we reached an MOU that any points of information and points of order to be spared from me for today. So I hope I can make my presentation as quickly
My
as
Lord, I
possible.
think this matter is not being given the seriousness it deserves. Mr. Kibe Mungai told you that book is part of the record, which means the entirety of the book has been filed. Unless it is on CTS, and unless every party has been given a copy, whether in original or in photocopy, it cannot be part of the record. And it cannot be done to say, I looked through the bar, I saw some people, because they are professors or they are this teacher, I have decided those few are the ones I'll give a book he wants to be on the record. A book we might never even have the time to cross-check, so it cannot be on the record. And we are not raising this as a frivolous point. That's just not how we do business. It has never been done that since the birth of the common law, 1076 AD. It is litigation. You want a material on record, every party must have a copy of that material. Thank you, my Lord.
Why don't you then wait for him to set the background, that if he makes any references which you are not satisfied with, then you raise an objection? Because at this stage, I don't know where this book comes in.
You see, my Lord, the problem I have is these proceedings may not end here. So if that book is part of the record and we don't have it, when the record of appeal for the next level is prepared, when the court ceases to consider that material, that's what I'm saying, it means something to say that a document is part of the court record. What I would have had him to say if he was doing this thing properly is he would have told you, I am seeking leave from you to put this material on the record, and I will serve it on all the council and all the parties, because that's how things are done.
I think I heard your lordships, the presiding judge, saying that we should photocopy the book and avail everybody, and that is being done, and the book is already referred to in our submissions and in our list of authorities. So I don't know whether this should be said in all local languages or sufficient that one is enough, because you have already given a direction.
I think, Mr. Mugwai, what you need to do is to avail the specific pages you have referred to.
Actually, I'll photocopy all of it and upload. That is the only thing remaining. My assistant Sylvia is here. She's organizing for that to be done. So before, and we shall start with serving Mr. Mulomi. Actually, his copy should be brought. So we shall bring all these issues to court. There is no big deal. You've given the directions. We photocopy the book. It's a small book. We shall photocopy. Sylvia is already doing it.
Proceed, please.
Yes, thank you, my lord. My lord, as I've indicated, the pleadings in this matter have been referred to this is a very small space, so we may not have any time to refer to pleadings. So the pleadings, they are in my bag there. So the pleadings are referred to in paragraph 2 of our submissions. This is at page number 5. Having now said that, I think the next important things to say is who are the 10th to 41st petitioners. My Lords, petitioners number 10 to 40 are public-spirited Kenyans, but more importantly, they describe themselves as part of the political constituency of the first petitioner in this matter. This is an impeachment, and impeachment from the High Court, Court of Appeal to the Supreme Court. We've had passages in the judgment saying it is a political process and it concerns political matters. They are the part of that constituency. The 41st petitioner, Gema Wadho Association, is an association of lawyers from Mount Kenya region who are over 1,000 and who are also part of this petitioner to try to seek justice with regard to the impeachment that occurred against the first petitioner. Having said that, my Lord, I wish to say that it is my great privilege to appear before a 3-judge bench of the High Court under the 2010 Constitution. I believe that matters. I had an occasion previously to appear before similar benches, but under the old Constitution. So why does it matter that we are appearing under the current 2010 constitutions? My Lords, as we have argued in our submissions, it matters a lot that justice in this case is required to be administered in accordance with the 2010 constitutions, because this constitution does 3 things. This constitution makes the fundamental Bill of Rights as a fundamental issue of justice, including rights like the right to fair hearing, issues like torture, that are absolutely protected by the constitutions. Number 2, it matters because, unlike the previous constitutions, it gives an elaborate framework in which all the arms of governments are supposed to be held accountable and to operate in a manner that is in conformity with Kenya's status as a constitutional democracy. We have set out what a constitutional democracy is and what it pertains, and what justice in a constitutional democracy ought to be. And issue number 3 is that we appear to this court with a lot of privilege for the simple reason that the Constitution says that the courts, and in particular, I dare say, the High Court, is a guardian of the Constitution. So to the extent, therefore, that it is the petitioner's case that the proceedings before you were carried out in such a manner that constitute a violation of constitutional democracy in Kenya, and under rules applied in a manner that makes a mockery of why in the first place we have a new constitution, then we shall be expecting that this honorable court will ensure that the constitutions of Kenya is not in any manner whatsoever violated, because there were very good reasons why we have that constitution in the first place. A while back, I believe this is 1996, I remember because I was a pupil at Kamau Kuria and Keraito Advocates, Firoz Noroji argued an article, very good, giving 10 reasons why we needed a new constitution. I will mention 3 for purposes of these proceedings. He said, 1, because we had ended up having an imperial presidency in Kenya and an authoritarian leader, contrary to the wishes that were understood that would prevail. Number two, he said that Parliament had ceased to represent the people of Kenya and had become sycophantic, and the people of Kenya in political matters and in public affairs had no political representation whatsoever by Parliament. But more importantly, my lords, he said that there was the failure of the courts. And this was the failure of the courts to endure that justice was administered in accordance with the rules of civilized democracies. This failure of the courts is an important one. And where did the courts fail? I think when I'm talking about the High Court, it is important that this point is made very clear. Mothomi Thiankuru had talked about the common law tradition. We got it from England. What happens and what we got from England is a notion of having a high court under the adversary justice system, fair system of justice, administering impartial justice based on law and evidence, and the applications of them to specific circumstances. In England, my lords, I believe most of you are aware of that, the full title of the High Court is a High Court of Justice. It is regrettable ours is just called the High Court. Probably it should also go by the full name, the High Court of Justice of Kenya. Why does that matter? It matters from our history, my lords, for the simple reason that when we said, and when, for example, Firoz Noroji wrote about the need for new constitutions because the courts had failed Kenyans, who failed? My lord, justice in any country and justice in the context of our constitutions can only fail if it fails in the High Court. If justice does not fail in the High Court, you are more likely to have a viable constitutional democracy. It doesn't really matter what happens before the appellate courts. The Court of Appeal, the Supreme Court. Those are appellate courts. They decide justice on the basis of what the High Court has decided. That distinction is absolutely clear because ultimately
ClickUp AI Note Taker is different than all the rest. It allows you to focus on your meetings, not your notes.
ought decides based on what the court issue the High Court has interpreted its mandate to be. And it is on that opening basis that I would want to impress and persuade your lordships that for this very important matter, justice cannot afford to fail before the High Court. My lords, I believe the law reports would confirm that I have been involved in numerous matters of constitutional importance. This is one of the 5th in my book that I believe is the 5 most important cases in this country heard by the High Court. It is important I mention them. In the year 2013, we had the High Court decision in the ICC eligibility case against President Uhuru Kenyatta and President Ruto. That was in 2013. It decided matters that are absolutely important, as we shall be coming to refer to you, and set the stage of ensuring how high voltage political matters ought to be adjudicated upon. Number 2, my lord, we had the famous Maina Kiai case. Everybody in Kenya, including lay people, know about Maina Kiai. Sovereignty of the people is exercised as a polling stations. And we had subsequently the BBI case. We all know the significance of the BBI. The basic structure is an important part of our constitutions. Then, my Lord, we had the High Court decisions that would go up to the Supreme Court concerning the budget for the 2023-2024 financial years. Those decisions, for better or for worse, are critically important for purposes of jurisprudence of the Kenyan High Court as a guardian of the constitutions. This is the fifth most important case in my book as far as jurisprudence is concerned in the High Court. And my Lord, as it were, just like I stand here today, probably I should have started by saying, you stand on the basis that there could have been another 500 or so constitutional lawyers who could have had the privilege to try to argue these important matters for you. So I will try, we are speaking to some extent for the legal profession. The same goes to your lordships. You are representative of the judiciary. How does this matter pan out in the Kenyan judiciary, in this very important high voltage political matter? My Lord, having said that, it is our submission that in dealing with this particular issue and in dealing with the special jurisdictions of the High Court, I believe we have dealt with that matter in several places where we shall be coming to. And mentioning this matter about the significance of this, I believe this was last year, sometime in September 2025. I read in the platform, I believe, on Nairobi Law Monthly, one of them, I have attached that speech by the Honorable the Chief Justice. She said, we have no time to quote, but there is a quotation in our submissions. She said that in marking the 15th anniversary of the 2010 constitutions, it is important that it must remain a living document, that it is important that it must retain its connections to the people, and it must serve the purposes for which it was intended to serve. Those purposes that it was intended to serve are well known, and we have said something about them. What is of crucial importance, therefore, is to say this, that, and this is, I have Githongori versus Attorney General in mind, that in adjudication of justice in this matter, justice must be dispensed in a manner that would make sense to ordinary people. Because it is only by making sense to ordinary people that the Constitution will retain its relevance, its importance, and serve its purpose and value to the people. In paragraph 12 of our submissions, that appears at page 8 to page 19, we have given a summary of what the petition originally filed as 570 is concerned about. And those 5 issues, number one, that we have highlighted to summarize what will be coming before you, is that the impeachment proceedings, in the view of my clients, was triggered by a political fallout between him and the 6th respondent. The 6th respondent is His Excellency, President William Samoei Ruto, as opposed to genuine existence of any grounds set out in Article 151B of the Constitution. And the petitioner's case will be that the impeachment against him was part of a conspiracy to use it as a tool for political management and resolutions of political disputes. Issue number 2 is that we shall be arguing that the proceedings before the National Assembly and the Senate were conducted in violations of the substantive and procedural provisions set out and envisaged in the Constitution and the standing orders in the respective houses of Parliament. Number 3 is that the 6th respondent's nomination of the second interested party as Deputy President and subsequent approval by the National Assembly is null and void and should be set aside. 4, that the impeachment of the first petitioner violates the political rights of the 10th to 41st petitioners, and it constitutes an affront on the presidential succession rules, and constitutes a premeditated subversion of constitutional democracy in Kenya, and it constitutes an attendant scheme to re-establish the imperial presidency. My Lord, on this important subject, we have referred, in our paragraph 13 of our submissions, we have cited a speech made by then Prime Minister Raila Odinga upon the promulgation of the 2010, sometime in August 2010. And what he said, it appears there for itself, that what this constitution meant is that it empowered the people. This constitution for him was important, that it dismantled the imperial presidency that we had. And this constitution, more importantly, made everybody accountable in terms of checks and balances that should exist. Those are important issues in our submissions that ought to be remembered as we deal with this important constitutional matter. President Mwai Kibaki himself, at page 17, is where the quotation occurs. He said that it is indeed that we had a very good constitution that protected the rights of the people. But he warned and cautioned Kenyans that they would need to have a lot of vigilance to ensure that the country will not go back to where it was coming from. And having that in mind, it is why sometimes when I have some discussion with my young lawyer friends like Dego Ajiro and others, I keep on reminding them, you must continue fighting for the Constitution, and the Constitution, somebody must fight for it, otherwise you would lose it. And why is that important? It is important, my Lord, because if the 2010 Constitution is supposed to be an antidote to tyranny, to dictatorship, then eternal vigilance that former President, the then President Mwai Kibaki cancelled is important. And I like reminding him and other young lawyers that, like Julius Caesar is reported to have said, it is I said, Julius Caesar was asked, and how did you turn into a tyrant? Julius Caesar is said to have answered, because nobody stopped me. I believe it is part of our obligations to ensure that tyranny cannot be re-established in Kenya without somebody trying to stop the re-establishment. My Lords, having said that, I come now to the special jurisdictions of the High Court with regard to impeachment. This is set out from paragraph 18 to paragraphs 26. I will highlight two or so things. The important highlight, my Lords, that is important to bear in mind, there is a decision in the Sonko case. This decision has been referred to by many of the advocates. I don't need to go through it. The relevant passage, I have quoted it also. But the critical issue that the High Court, the Supreme Court said, is that it is very important that the rights of the people and the procedure that is adopted during impeachment proceedings are subjected to review by the High Court. It is the High Court that reviews. It is the High Court that protects fundamental rights. Everybody else decides whether the High Court did its job or otherwise. What does this mean? What this means in practical and in a technical sense, and our constitutions, is that Article 48 of the Constitutions and Articles 27, the right to protection of law and the right to fair hearing, and Article 50 of the Constitutions. When the Constitution says that you have a right to a fair trial, or you have a right to fair procedures, and you have the right to protection of law, it ultimately means that anybody else who is a court of first instance whether you are a magistrate, whether you are a tribunal, and whether, like the Senate, you are presiding over a trial as a political court, you are ultimately subject to the High Court. What does this mean? What this means, my Lord, is this, that I consider that an impeachment ultimately leads to the loss of office, the removal of a person from office. These important rights, the rights to protection of law, the right to hearing, those rights I submit concerning governors. I don't know whether there are exceptions, but all the matters that I am aware, I cannot remember whether there is any governor who was replaced before the High Court had a say on reviewing and determining whether the removal was fair or was in accordance with the law. So that, I am in other words saying, we must have started here on the wrong, to have had the wrong start. In the sense that, here we had a situation where, despite the very serious issues of violations of law that occurred, the first petitioners nevertheless lost his office and was replaced before the High Court had an opportunity to say whether this is right or this is wrong. That is fundamental, and that is a game changer, because it effectively means that lower bodies there can be able to administer justice without any supervision and without the right of an aggrieved Kenyan to go to the only court that is truly guaranteed for purposes of ensuring that justice is delivered. So that is an absolutely important issue. And therefore, my Lord, as we also deal with this issue of the special jurisdiction of the High Court, it is also important that I state this, that when you read the constitutions of Kenya, you will find that the Constitution does not provide for the procedure of removing a deputy president. The constitutions provide for a procedure to remove the president from office. The significance of this, you will be able to see it shortly. When you have it 150, Sabbatical 2, that Parliament will be required to modify the procedure for the removal of the president to fit into the removal of the deputy president, that does not change the key issue. The key issue is that when you talk about Article 145, you are really talking, and which is the substantive procedure, that we are really talking about the president, not the deputy president. And more significantly, as it were, and it is one of the grounds we shall be arguing, Parliament did not actually modify, obey the command of the Constitution.
Na mtazamaji, bado kamera zetu ziko pale pale zikiwa zinafuatilia. Kumbuka tunafuatilia leo na kesho, lakini kwa hivi sasa nataka nikupeleke moja kwa moja hadi Naivasha, maana kuna kongamano la elimu la kitaifa la elimu ambalo linafanyika katika siku hii ya leo, ambapo Daktari William Samoei Ruto, Rais wa Jamhuri ya Kenya, atarajiwa kuweza kuongoza kongamano hilo ambalo limeweza kuleta waziri wa elimu pamoja na makatibu wake watatu katika wizara hiyo na wadau wengine, wakizungumzia masuala muhimu kama vile sera ya elimu yetu, kuweza kuangalia mfumo wa CBC, mafanikio yake na changamoto zake, kuja kuangalia pia vile vile utaalamu ama viwango vya elimu vya wale ambao ni walimu ambao wanatoa elimu hiyo, miongoni mwa masuala mengine, bila kusahau pia swala zima la mfumo wa ufadhili wa vyuo vikuu. Mtazamaji, kuna mengi atakuwa yanazungumziwa. Nipe nafasi hivi sasa, nimpe Emily Chebet atujengee taswira fupi, yani kina nani ambao wamefika hadi kufikia sasa, na anaamini kwamba katika siku hii ya leo ni swala lipi ambalo litapewa kipaumbele. Emily Chebet.
Naam, asante sana Rashid. Tuko hapa katika eneo la Naivasha ambalo kuna kongamano la pili la kimataifa la sekta ya elimu. Amekongamana hapa na Rais William Ruto, wasili katika eneo hili ambapo wanatarajiwa kufungua rasmi kongamano hili ambalo litaendelea kwa siku mbili. Washikadau hawa katika sekta ya elimu wanatarajiwa kuzungumza masuala mengi tu wakati huu ambapo ule transition ya grade 10 ambao umefanyika mwaka huu, na pia kuangazia iwapo kama wanafunzi, walimu na pia wazazi kama wako tayari kuendelea na mfumo huu wa CBE. Baadhi pia ya masuala ambayo yanatarajiwa kuangaziwa hapa ni iwapo vyuo vya kiufundi ama zile TVET wameweza kujitayarisha vilivyo, na pia vyuo vikuu kama tayari wameshajiandaa. Maswali mengi tu yatakuwa hapa, na tutakuwa na Rais William Ruto ambaye atazungumza. Pia tuko na Waziri Migos Ogamba na wale maafisa wote wa serikali pamoja na unions kwa shule. Je, iko tayari? Kumbuka kwamba tumekuwa na masuala mengi zaidi, baadhi yao ikiwa ni kwamba kuna wanafunzi bado wamesalia nyumbani. Je, tutaweza kupata leo ni sababu gani? Na pia leo tutaweza kusikiza pia yale maswali tu mengi kuhusu school fees ambao tunapata walimu wanaweza kuitisha wazazi. Je, is funding education kama iko tayari ama ni maswali gani mengi? Kwa hivyo tutakuwa tu hapa na tutarudi kwenu tuweze kuwajuza mengi zaidi hapo baadaye, lakini kwa sasa tunaweza kuona katibu katika Wizara ya Elimu Dr. Inyangala ndiye anaweza kufanya ile introductions za maafisa wao, kisha tupate Waziri Migos Ogamba ambaye atakaribisha Rais William Ruto. Rashid.
And across the whole ecosystem, basic and TVET. You have challenged us, Your Excellency, to think differently, to work differently, so that we can transform in due course. Today, the conversation has changed. It is no longer whether the reforms can work. It is about how we can innovate in our different spaces to make this work, to deepen the transformation. And I want to assure you, Your Excellency, that the spirit is collaboration. We are collaborating with private sector across the different sectors of public service, with NGOs and with development partners, and the results will speak for themselves. Your Excellency, at that point, allow me to introduce the stakeholders of the higher education sector. Kindly stand and wave to Your Excellency when I call you. The chairs of councils of public universities and their governance teams present here today, led by Professor Bosire Mwebi. Let us appreciate them. Thank you. The chairs of semi-autonomous government agencies in higher education and the TVETs. There are many, so I'll not mention them. Please stand along with your teams. Let us appreciate them right there at the back. Vice chancellors and principals of public and private universities, as well as principals of national polytechnics, TVETs, and the Kenya School of TVET, and your teams. Let us appreciate them. We also have a few comrades from the TVETs and the universities. Let us appreciate them. We have representatives of UASU, KUSU, and KUDHIA. They are welcome to this conversation. Let us appreciate them right there at the back. And last, but definitely not least, Your Excellency, we are accompanied by staff from the State Departments of Higher Education and TVETs. Kindly stand so we can appreciate you. Thank you, Your Excellency.
Your Excellency, on behalf of the elected leaders, allow me to introduce the Chair of Education Committee to be able to introduce the leaders present in a minute before I invite the Cabinet Secretary. Karibu Mheshimiwa Julius Meli. Let's put our hands together as we receive Chair Education Committee, and thank you very much for Parliament helping us to get the resources.
Your Excellency, the President of the Republic of Kenya, Honorable William Samoei Ruto, CS Migozo Gamba, Principal Secretary is present, senior government officials present, and all education stakeholders. Good morning. First and foremost, Your Excellency, let me thank you for being educationist number one. In what sense? That this conference is the second time we are doing it this time, because it is the time when we listen to the stakeholders and bring the society and the needs as per what they have brought before us. I have come before this conference to this morning, but more importantly, to know that National Education Conference is a conference accepted by our Constitution. This is a stakeholders meeting where we share ideas, where we sit together, talk to one another, and make education what we need. Education is the pulse of the society. So I've come with my colleague members of Parliament. We'll be sitting here. We'll listen to you. We'll want to know how much costings you put into basic education, more so competency education in primary, all the way to the university. We'll want to know the various pathways and the various issues that you have in terms of human resource, because it is in the House that we have the national pass. So, Excellency, we are here to listen. We are here to also listen to them, the proposals on the legal issues, especially the legal proposals or amendments you'd want to have in the House to make education effective and to have the leadership of the sector well. So we'll sit through this meeting and we'll do a lot of listening. And at the end of it, we'll be able also to respond to a number of issues. So I'm accompanied by Honorable Liz Chelule, who is the women rep, or county MP, Nakuru. We give her a clap. We are also accompanied by Honorable McClap, who was a veteran teacher and a member of Parliament, Baringo North. Give him a clap. Other members of Education Committee will be joining you, and other members of Parliament, I know from within this county, and we shall be glad to listen and to be able to make our presentations later. I thank you. Thank you so much.
Thank you very much, Honorable Meli. Your Excellency, sir, allow me now to invite the Cabinet Secretary, Honorable Julius Migozo Gamba, to make his remarks. Let us put our hands together to invite Waziri. Karibu sana, Waziri.
Thank you, Professor. Your Excellency, the President of the Republic of Kenya and Commander-in-Chief of the Defense Forces, Dr. William Samoei Ruto, honorable members of Parliament here present, PSS present, my colleague delegates, ladies and gentlemen, good morning. Your Excellency, allow me to begin by thanking you most sincerely for finding time from your busy schedule to grace this opening ceremony of the second National Education Conference. This conference is a follow-up of the first national conference that we held last year. It brings together key stakeholders in the education sector, including the ministry and state agencies, teacher unions and teacher associations, education administrators and regulators, institutional sponsors, development partners, universities, TVET institutions, professional associations, learners, and the faith-based organizations spanning the entire education continuum from pre-primary to tertiary institutions. This forum, Your Excellency, will review the progress that we made, especially in the rollout of the competency-based education, whose first cohort is now successfully settled in grade 10. It will also examine the many transformative reforms that we are implementing to ensure that our education system remains fit for purpose. This meeting will discuss authentically about what we are doing in the sector with a view to ensuring that we get the solutions that we require. Your Excellency, the theme of this conference, driving effective education reforms through leadership and accountability, is particularly timely as we undertake extensive reforms across the education sector. As stakeholders, we have agreed to work collaboratively, identifying and resolving challenges that arise in our sector in the course of implementing these reforms. Under your leadership, Your Excellency, our collaborative approach has continued to produce impressive results as we strengthen this sector day in, day out. In the basic education subsector, Your Excellency, your administration has employed over 100,000 teachers, with a further 16,000 expected to be recruited in the financial year 2026-2027. Additionally, 23,000 classrooms have been constructed. The first cohort under the competency-based education are successfully transitioned to grade 10 at the rate of almost 99.5. Further, Your Excellency, your administration has increased the education sector budget from 503 billion in the year 2021-2022 to the proposed 767 billion in the financial year 2026-2027, which is almost 30% of our budget. Your Excellency, capitation funds are now being released to schools on time, making a significant milestone in improving efficiency and stability within our sector. In the TVET subsector, enrollment continues to rise steadily, and we are progressing towards our target of 2 million. We are currently at almost 800,000, having moved from 297,000 in the year 2022 when this administration took office. Additionally, we've employed 3,300 trainers with an additional 1,000 set to be recruited by July this year. Training fees in these institutions has also been reduced to 67,189, thereby making it possible for more students to join our programs. The curriculum has been modularized, meaning certification can now be done within a shorter period, enabling people to be able to acquire skills to earn a living as they continue progressively scaling their skills. We have introduced policies in the sector that are learner-based or trainee-based. For example, we now have the recognition of prior learning and the dual training policy in place that continues to support our learners. In the higher education subsector, Your Excellency, we've addressed persistent industrial unrest that previously affected that sector by establishing mechanisms for timely engagement and resolution with our unions. The means testing instrument has significantly improved, while tuition fees in higher education has also been reduced by between 15 to 40%, thereby making education in the higher subsector more accessible and more affordable. Our institutions and universities, Your Excellency, are also preparing adequately to receive their first cohort of the CBE learners in 2029. And part of the discussions here today will be how is that going to be undertaken. Your Excellency, leadership and accountability remain the twin pillars of transformation in our education sector. Teacher union associations, education officers, quality assurance officers are working complementarily together to ensure that we receive the responsibilities or we are able to get solutions together. Our collective leadership must therefore remain clear, collaborative, and responsive, and accountable. To all delegates here present, I urge you to engage openly and honestly. Be authentic in your discussions so that together we can develop a practical and sustainable solution basis for the advancement of our education sector. In conclusion, Your Excellency, allow me to once again thank you for the immense support that you continue to provide in the education sector. On behalf of the entire sector, I assure you that we will remain steadfast and committed to ensuring that investments made in this sector yield the desired outcomes in our learners and in our institutions together in our nation. Ladies and gentlemen, it is now my distinct honor and privilege to invite His Excellency the President to deliver his remarks. Please be upstanding as we welcome His Excellency. Asanteni sana, Mungu awabariki.
Thank you. Thank you very much, Waziri. Please, another round of applause for Waziri. I think this gentleman has done an outstanding job. Asanteni sana, tafadhali tuketi. Asante. While I was sitting here and looking at the writing here on this sheet here, I was asking Melly, I am a scientist. I am not a linguist. And I was asking whether competency or competence. Some English teachers should help us, whether it should be Y or mutatueleza baadaye. Distinguished guests, ladies and gentlemen, the conversation at this second National Education Conference is of such profound significance to the future of our country that it demands our full, collective, and undivided attention. This is because we are meeting at a profound moment in our country's development journey. As an administration, we are implementing the bottom-up economic transformation agenda with a clear focus on expanding opportunity, strengthening productivity, and ensuring that no Kenyan is left behind. Equally important, we have made a bold national commitment to propel Kenya into first world status in our time. Global experience informs us that countries that have fulfilled their development ambitions, from Japan to Germany and South Korea to China, Singapore to Israel, did not treat education merely as a social good, but as a national mission and a strategic national assignment. Allow me to share 5 broad reasons why education is and must be central to our development agenda. First, education develops human capital by equipping citizens with literacy.
Every sunrise brings a new beginning. At Mount Kenya University, dreams rise with it. From bold ambitions to breakthrough discoveries, from classrooms to laboratories, from determination to graduation day. Here, passion turns into purpose. This is where futures are built. Mount Kenya University, unlocking infinite possibilities.
Field workforce, technicians, scientists, innovators, and many more. Third, education strengthens the capacity of the state. A competent civil service, an effective judiciary, a professional diplomatic corps, sound planning institutions, and efficient regulatory systems all depend on educated and capable citizens. Fourth, education enables innovation and the adoption of technology. strong universities, research institutions, vocational systems, and digital skill ecosystems enable countries not only to adopt technology faster, but also to innovate and create technologies of their own. And fifth, education transforms societies. It reduces poverty, improves health outcomes, lowers maternal and child mortality, expands opportunities for women, strengthens social cohesion, and promotes civic stability. In many ways, ladies and gentlemen, education is the single greatest investment a nation can make in managing its present and shaping its future. Indeed, the United Nations Educational, Scientific and Cultural Organization, UNESCO, estimates that in developing countries, every $1 US invested in education can generate up to $15 US in economic growth. Distinguished educationists, with that broad context, the theme of this conference, driving effective education reforms through leadership, accountability, and collaboration, captures the core principles guiding our work and the engagements we're going to have in this conference. It speaks to the responsibility we all share to ensure that education reforms are not only well designed, but also effectively implemented and sustained across all levels and all systems. A working education system demands continuous and vigorous evaluation and review to align it with aspirations behind its introduction. This forum is therefore ideal, as it offers an opportunity for candid reflections on the state of our education. It is also an opportunity to assess our successes and reset our priorities. And congratulations, Warisiri and your team, for putting this forum together. I know this is the second forum. The first forum, I wasn't able to attend. But on being briefed on the engagements in the first forum, I made the decision that I will be coming to this forum every year because of the significance and the importance of not just education, but the need for us to collaborate, harness ideas, correct where there are wrongs, and streamline the whole education program because, as I have said, it is the single most important investment any society, community, or nation can invest in. And that is the reason why close to 30% of our national budget is spent on education, not as a cost, but as an investment. It is the reason why we have progressively enhanced the budget in this sector from approximately 500 billion in 2022 to 702 billion in this financial year and 767 billion in the coming financial year. We don't treat the investment and the resources we are putting in education as a cost to us. It is an investment we are making in our present and in our future. And that is why the theme of this conference leadership, accountability, which comes with integrity, and also collaboration is a very apt theme that brings us together to realize that reform requires bold leadership, because entrenched cultures don't give way easily. So we have to be courageous and bold to be able to implement the reforms that will align our education with the needs of the present and with the aspirations of the future. Accountability becomes a very central part of delivering on education, because the resources we are allocating, the public taxes that we allocate to education, 700 billion shillings is a lot of money. And integrity must be front and center in us delivering on education and making sure that we can account to the Kenyan public on the resources we are spending in education. I have been in this space for a while, both as a member of parliament and subsequently as a minister for higher education. And I know full well how important and how impactful delivery on education can be to not just our learners, but to our society in general. It is the reason why I instructed the Ministry of Education to do a proper audit and to take the next step and digitize education data. You know, you will be well to know that when we carried out audit and when we decided to verify the numbers of students in primary school, the numbers of students in secondary schools, the numbers of schools themselves, you know, we got to know that there were 87,000 or thereabout ghost students in our secondary schools. Students we were paying capitation for, yet they didn't exist. We had 800,000 pupils in primary school, government paying close to $1.2 billion every year for learners that did not exist. We had schools registered, close to 200 schools that did not exist. We are asking some very difficult questions to some of our head teachers and to some of our leaders in education at the county level. Because accountability, integrity is central to us making sure that all our resources are used properly. You will also want to know that because of this, we are now moving to the next step. And I have instructed the Ministry of Education that in the next 2 months, we're going to be working with the Consa Technopolis, to make sure that we digitize all the education details of every learner, every school, teachers, bursaries, and everything else, so that we can make sure that through technology, deployment of technology, using digital data, we can easily check on whether we have the right number of students, whether we have the right number of teachers, where we have gaps, and what we need to do. And progressively, we have seen what technology has done. I will give you an example. We had very big difficulties with agriculture. We decided that we are going to digitize all our farmers. We're going to collect data on all our farmers. We had tried it before for a very long time, almost 10, 15 years. We only registered 300,000 farmers. But we did a national exercise, rolled out a whole of government approach. Today, we have 7.2 million registered farmers. We know how many sugarcane farmers, how many coffee farmers, how many tea farmers, how many growers of wheat, how many growers of maize. Today, for you to buy fertilizer, you have to bring a digital voucher because we allocate every farmer, because we know farmer X has 5 acres. He cannot come and claim fertilizer for 20 acres because he doesn't have 20 acres. So the system automatically knows and allocates fertilizer on account of the acreage of farmers. We have dealt with huge cartels that were big problems to us because we digitized data. I want to encourage stakeholders, from our teachers to boards to parents, for all of us to agree to a digitization process so that it makes it easy for us to deploy all the resources we are deploying, whether it is capitation, whether it is bursaries, and everything in between. I am happy that we have teachers and teachers' representatives in our midst. The question I will ask my good friend Oyu and and my sorry, the leadership from Kupet. Oyu, sorry. The question I'm going to ask them is, we have some head teachers who have taken us to court that they do not want to pay parents to pay school fees on e-citizen. They want to continue writing receipts on pieces of exercise book. Why? Honestly, mutusaidie. Why do you want to continue writing receipts on pieces of paper where nobody, traces your exercise book iliandikwa ilipotea, shule ilichomeka ikachoma na receipt, sijui nini? Today, parents should be able to pay from the comfort of their homes on e-citizen school fees for their children, where we can verify the data, where we can know that this money was paid. We have made a decision. I have made a strategic decision that we do not want to deal in cash in this administration, because cash is very sticky, And that is why today you can pay literally for any government service, on a digital platform, through M-Pesa, through the bank, so that you have traceability and we can have visibility as government that so much money has been paid. So mutatusaidia Bwana Uju na Maisori na wadosi, mtuambie hawa watu tuwachane na giza please. Wacha tukuje mahali kwa mwangaza hapo, kila mtu aonekane nini inafanyika, pande gani inasonga namna hiyo. You know, I don't think asking for transparency is too much, right? But I'm talking about very few teachers. The rest of the teaching fraternity, many schools across Kenya today, they are accountable. They accept money to be paid on a digital platform. In fact, I have head teachers who have rejected cash. They say they've told parents, go pay using a digital platform because we want accountability. This is how we want to move into the future. And that is why I have singled out your theme here of accountability. If we are accountable, we can do more with the resources we have. And we can improve learning outcomes better with the resources that we have. This year, you know, the first cohort of grade 9 learners under the competence-based education joined senior school with over 99% transition. We must safeguard the unique ability of education to be an equalizer for all by eliminating man-made bottlenecks that frustrate access to quality learning and stand between our children and a brighter future. Equally important is making available the necessary learning resources to our schools on time. Beginning this year, we have ensured that capitation funds are disbursed to public schools before the opening date. We are also accelerating the expansion of classrooms, laboratories, and other learning facilities to cope with the growing number of learners and the demand by the CBE curriculum. These reforms are reshaping our classrooms into spaces that nurture creativity, build practical skills, and prepare learners for real-life challenges. They are laying the foundation for a generation that is not only knowledgeable, but also innovative, adaptable, and capable of providing needed solutions. Indeed, even in the face of early skepticism, the results we are now witnessing speak for themselves. Learners who have transitioned to senior school are already demonstrating strong learning outcomes that affirm the soundness of our decision to reform the curriculum. The core competencies and values being inculcated, including critical thinking, communication, collaboration, and citizenship, are evident in how these learners engage with their teachers and interact with their peers. Their confidence, creativity, and the sense of responsibility are clear indicators that we are on the right path. This progress has been driven by deliberate and sustained government action. Since taking office, you've had the statistics as given by Minister Ogamba that we had 4 fundamental challenges in this education space. We had a serious challenge with competence-based. Many parents were complaining they are being forced to do homework at night. They are making cars at night, cutting boxes, and doing all manner of things. We had serious challenges with teacher numbers. We had a huge gap of close to 100,000. We could only hire 5,000 teachers every year. We had serious challenges of learning spaces. I will give you an example. In Nairobi alone, we've had to provide additional resources to create more learning spaces in the city of Nairobi. We're building an extra 1,000 classrooms in the city of Nairobi alone, just to make sure that the students, especially in informal settlements, have access to education. We had very serious challenges of the funding model that was more focused on the institution than the learner. We have since corrected all of them. And of course, we have 2 to go: digitize the whole system so that we improve on transparency and we make it much more easy for decision making. And number 2, I have one last thing that I must do, and that is to sort out a higher education loans board so that we can have clarity. And I have instructed this man, that, and I've put him together with my team. I've given them some assignments that we must finally end up with a predictable, you can sit down, Monari, with a predictable resources. Because as we move some of our commercially viable programs out of the budget into the National Infrastructure Fund,